All right, it's 8:30 by my clock, so I think we can begin with the 8:30 docket. This is Judge Krier again. First case on my docket is Web Roofing versus United Property, 20 CA 1192. It's a motion to withdraw. Mr. Kreskis, are you here someplace?
Yes, ma'am.
All right. Anybody else? Anybody here for defendant?
Good morning, Your Honor. Attorney Mark Stewart from Turwell Law.
All right. Well, the motion complies with the rules, so there's no reason for me not to grant it. And what I've been doing in these web roofing cases is giving them 30 days to hire new counsel, requiring that they include the language that about the consequences if they don't do that. But it will abate things for 30 days. Do you have anything you want to tell me?
No, Your Honor. I've seen other orders on the same motions, and I do not oppose.
All right, Mr. Kreskis, if you get me an order to my office email address in Word format, please.
Yes, ma'am.
All right, thank you.
Thanks.
Thank you, Your Honor.
All right, next case is Carroll versus Fahada Sahad and Alice Dolben, 20 CA 2252. Who's here for the plaintiff?
Good morning, Your Honor. It's Richard Weldon.
All right, anybody here for defendants? Nope. Okay, this is also a motion to withdraw.
It is, Your Honor.
It looks like you've complied with the rules. Anything you want to tell me about it?
No, Your Honor. It's just irreconcilable differences, and there's just some considerations that both professionally and ethically felt that it was necessary for me to file this motion, Your Honor.
All right. So I will grant your motion if you forward me an order that includes the language from I have some language on my web page in a download that outlines that people have a certain amount of time to obtain new counsel. If they don't, we assume that they're going to be proceeding pro se. If they're an entity, there's certain consequences, etc. But I'll give them 30 days to do that.
Okay. Very good, Your Honor.
All right. Thank you, sir. To my office email address in Word format.
I will. Thank you.
All right. Thank you. All right, next is Superior Landscaping and Lawn Services versus City of Naples, 20 CA 2822. Who's here for the plaintiff?
Good morning, Your Honor. Scott Lombardo for Superior Landscaping.
All right, and who's here for defendant?
Good morning, Your Honor. Sarah Hall on behalf of City of Naples.
All right, so this is plaintiff's objections to defendant's subpoenas.
Yes, Your Honor. Mr. Lombardo and I had been working diligently to resolve most of these matters, and the depositions of the corporate representative and one of the principals of Superior, as well as the records custodian, are proceeding tomorrow and Friday. So based on what I expect to get by end of business day today, I think that we've whittled it down to one issue that we are still seeking direction from the court on. Okay. We may have subsequent issues later, but I don't think that we need to have that addressed today.
Okay.
This addresses the request to produce on the subpoena ducis tecum items number 26 and 36 through 41. Essentially, the City of Naples is asking Superior to produce documentation regarding other contracts with government entities, such as the Lee County government or Collier County government, in the area for the time period that covered the contract at issue in this lawsuit.
Okay.
And the basis
for what purpose? How is that relevant?
Yes, Your Honor. The basis of that is there is a provision in the contract that indicates that the bidder, in this case Superior, will not accept any other work in a similar area geographically and for similar services to be provided. And the main issue that we have with regard to the contract is non-performance. And as part of the city's contract, the city requires maintenance logs to be submitted. And whether or not those were submitted and whether or not those are accurate are the core issues that we're addressing with this lawsuit. And we do have many maintenance logs that have been submitted at various points in time, but we want to be able to connect them specifically, if possible, to the City of Naples and not just work that was provided in Collier County.
Okay.
So we do find that the basis for, I apologize, I paused a little long.
That's all right. Go ahead.
We do also allege that there was a previous breach of the contract by Superior, and one of those provisions that was breached is that not a non-compete, but an agreement to not bid on other similar projects in this geographical area. So it's relevant for those two reasons.
All right, Mr. Lombardo.
Your Honor, so there's a few things here. The first off is that these subpoenas were sent with, about 2 to 3 weeks of heads up time before the depositions were scheduled to take place. And only after we agreed on these dates for the depositions was this laundry list of ducis tecum requests submitted to me. As you know, the request for subpoena documents should follow the same requirements as a request for production, which would be 30 days. Naples in this case has
Not if it's not parties. Hold on just a second. Who's not muted? Somebody's not muted, so I don't know who that is. Anyways, go ahead.
And Your Honor, so we're only in the process now of responding to Naples' request for production, and we're going to be giving them our entire production today as agreed. And only with about 2 weeks notice were we given this list of requirements for additional documents to find and bring in time for these depositions.
Okay,
but
but these are issues that are easily solvable. You just move the deposition dates. And of course they can't subpoena the documents until you guys agree on dep dates, because why issue the subpoenas before you actually have a date? To me, this is a practical problem, not a legal problem.
Right, and I agree with that. I assume it would be because of the arbitration that we had scheduled. But to get on to my next point, Ms. Hall's reading of what she claims is a non-compete in the contract, I think it's a misreading. It's a very limited provision that says that we can't accept compensation for services in the same area, the same scope of work. Basically, we can't be doing the same type of work in the same area for another entity. So therefore, as you mentioned, we don't feel that this is relevant at all, because this is asking for Superior Landscapes contracts with other counties. This lawsuit deals with non-payment by Naples for work for Naples in the city of Naples only. I don't see how relevant we could find Superior's contracts in Collier County, Lee County. And not only is she asking for those contracts, she's asking for those contracts from 2017 until now, I believe. It's either 2019 or until now.
Okay, so what provision of the contract are we addressing? I'm looking at the contract.
I believe it's 1.8.
Okay.
And I don't have it in front of me.
I've got it in front of me. Okay, 1.8 says the contractor agrees not to provide services for compensation to any other party other than the city on the same subject matter, same project, or scope of services as set forth in this agreement without approval from the city council or the city council of the city. So that's a pretty broad non-compete, for lack of a better term. I'm not sure it would be 100% enforceable, but that's not really what we're talking about. It doesn't limit it. It doesn't limit it to area. So,
well, yeah. So
theoretically, those contracts would be relevant. And let's look at their answer. I'm assuming what is in play here is that they're alleging your client didn't provide services because they were off doing other work.
Right, and I told Ms. Hall that she's free to ask about this in deposition, but to my knowledge, I haven't heard this alleged in any of the pleadings to this point.
I'm just looking at the answer that was filed. Where in your affirmative defenses, counsel, did you allege something along these lines, like non-performance or something?
Yes, Your Honor, I'm trying to look for that now. There were affirmative defenses and amended affirmative defenses that were filed at the request of plaintiff's counsel that specifically addressed this provision. So I'm looking for the original one.
Okay, I'm looking at the one that was filed on February 2nd, 2021.
That would be the amended, if I could have a moment to locate it, Your Honor.
And then the other one is was filed on, hold on. September 29th, 2020.
And again, Your Honor, it's not simply the contract provision that makes these relevant. It is also...
Well, you did allege in affirmative defense number 8 that the city of Naples is excused from performance due to plaintiff's unjustifiable and substantial prior breach.
And also the issue is there are handwritten time cards that were just produced at the last deposition we conducted, which I think was last week, it might've been the week prior, that indicated if those documents are accurate, that there were staff members of Superior working somewhere for 8 hours every day. And that contradicts other documents that Superior produced with regard to what they did as far as work for the city.
I got it. Okay, so I'm going to overrule the objections and require that the documents be produced. However, in terms of the practicality of it, I mean, again, if you need more time, it wouldn't be unreasonable if this is burdensome.
And
which just means it's going to postpone a lot of things, which I am not particularly concerned about, because I think you guys are proceeding timely and well, but that's really up to you all.
And Your
Honor, I would request that he be
hold on, Mr. Lombardo, go ahead.
As to the time.
Oh, Mr. Lombardo, I want to hear from Mr. Lombardo.
I apologize.
I would ask that he be limited to contracts from 2018, because that's the only time period where there's non-payment being alleged in this contract.
And Your Honor, we would agree for 2017 and 2018. I didn't understand that Mr. Lombardo construed this all the way through 2021. That's certainly not what the city is looking for. And I would agree that wouldn't be relevant. With regard to the time to produce, these requests, although they may be more nuanced with regard to the items 26 and 36 through 41 in the subpoena ducis tecum, the requests for production were sent well before the subpoena ducis tecum with regard to the case overall. So these have been at issue, and the request for production would be overdue, except that Mr. Lombardo unfortunately fell ill. And so the city agreed to delay the production until today so that he would have time to produce.
Okay,
so
well, I will require the production for 17 and 18. And again, I'll give you 30 days from the issuance of the subpoena if you guys agree to reschedule everything. I mean, you're going to have to reschedule your depositions, your arbitrations, everything. If you want to do that, that's up to you. But if you don't want to do that, then proceed along and get it done. So I'll need an order from you, Ms. Hall, after you've circulated to my office email address in Word format, please.
And Your Honor, one point of clarification, when would the production be required if the parties are not going to agree to postpone the depositions and arbitration?
5 o'clock today.
Okay. Thank you, Your Honor.
Yeah, the depositions tomorrow, so.
Yeah.
All right, thank you.
Thank you.
Thank you.
All right, next is Tibstra, 19 CA 35. Mr. Bender, you're here representing who?
Yes, Your Honor, Marshall Bender on behalf of plaintiffs.
All right, and Mr. Tibstra is also here, I see. Yes.
Yes, I am. Thank you very much.
This is a motion to strike defendant's demand for a jury trial. Mr. Bender, go ahead.
Yes, Your Honor, we discussed this briefly at the case management conference we had a few weeks ago. There was some confusion with respect to whether or not the defendant had properly requested a jury trial, demanded a jury trial in his pleadings. After that case management, defendant did file a demand for jury trial, so that is before the court today. We filed our motion to strike the defendant's demand for jury trial on April the 26th of this year. Judge, as we point out in the motion, there were previously counterclaims filed by the defendant, which would have granted defendant the right to a jury trial. However, the court has dismissed those counterclaims with prejudice. The sole claim remaining in this action is an equitable claim to remove defendant as trustee of a life insurance trust for which he has been temporarily removed by this court. As we have pointed out in our motion, Your Honor, under Florida law, the test for determining the right to jury trial is whether or not the party seeking a jury trial is seeking to invoke rights and remedies enforceable in an action at law. It's well established that where a right or remedy is equitable in nature, there is no right to a jury trial. Judge, this is clearly an equitable action at this point in time. It's a one-count claim to remove Mr. Tibstra as trustee of the family trust. We've cited case law to you in our motion, providing that these kind of claims are equitable claims. Furthermore, as we discussed at the prior case management conference, Florida's trust code provides the court the authority to remove a trustee. That is what is being sought in this one count claim. So we would ask that the court strike defendant's demand for jury trial. I understand defendant has, emailed some purported authorities in support of his demand for jury trial, but those do not go to the issue of whether or not an equitable claim to remove a trustee from a trust provides a defendant the right to a jury trial. The authorities we cited in Florida Trust Code clearly established that defendant is not entitled to a jury trial under these circumstances. So his demand should be stricken by the court.
All right, Mr. Tipstra.
I feel it is imperative in my case to have a jury trial, because a jury trial in this case could assess the case, because my father used mail fraud with the help of John Hancock and Merrill Lynch agents to keep all the documentation to himself. For many years, I've tried to meet my fiduciary responsibility. John Hancock's agents have stated clearly that I was receiving the statements, that they were under the assumption that I was receiving these statements. However, they would not allow me to change my address. Instead, the address was changed to both my father's address and the address of the Merrill Lynch branch in Naples. With that being said, I had no access to the personal mailbox 600 in Naples.
Okay, Mr. Tipstra, you're
Yes.
arguing the facts of your case. That's not exactly appropriate here.
Okay, well, I am simply stating my facts of my case for a jury trial because I feel it's imperative to have a jury trial, for the subjectiveness of this matter would be unjust if not served by a jury trial.
Okay. Mr. Bender, any response?
The authorities I referenced in the motion, clearly provide that Mr. Tipstra is not entitled to a jury trial in this action, and so his demand should be stricken.
All right, I am going to grant the motion to strike the demand for jury trial based on the legal authority cited in the motion. Also, let me just take a look. You guys are set for trial. The last trial order was from April, so we need a new trial order. Where are you in your discovery or whatever you need to do, Mr. Bender, and then I'll go to Mr. Tipstra.
Yes, Your Honor. At our last case management conference, you directed us to send you an amended case management plan, which provides for deadlines to provide a witness and exhibit list, with the idea being that we would go to non-jury trial in the month of July. We've submitted that to the court. I don't know that we've received.
Oh, I haven't seen it. Okay, I'll just make sure that the trial order gets done.
Yes,
all right, I just wanted to make sure we were on track.
Yeah.
All right, thank you, everybody. Mr. Bender, I'll need an order to my office email address in Word format after you've sent it to Mr. Tipstra. All right, thank you. All right, next case is Podzik versus Creative Hardscapes, 19 CA 2786. Who's here for the plaintiff?
Good morning, Your Honor. Kristen Stocks on behalf of the plaintiff.
All right, how about defendant?
Good morning, Your Honor. Andre Sessler on behalf of one of the defendants. I have co-defense counsel with me as well. I see her information on the bottom here, but I'm on behalf of Creative Hardscape.
Good morning, Your Honor. Lisandra Guerrero on behalf of Blue Haven.
All right, hold on just a second. Let me pull your case up. All right, this is a joint defense motion for dismissal with prejudice, based on the fact that there has not been a timely substitution of the estate for the deceased person.
Yes, Your Honor, or in the alternative, of course, a dismissal without prejudice, if Your Honor is so inclined.
Yeah. All right, go ahead, Mr. Sessler. Are you arguing this?
Yes, I am, Your Honor.
Okay.
Good morning. Thanks for your time. So just to be straight to the point, this is a matter involving an elderly individual who at some point slipped and fell into a construction zone, a pool. The incident occurred on May 14th, 2018. About 2.5 years later, the plaintiff passed away. So November of last year, November 18th, the suggestion of death was filed December 1st, 2020. And I think we're all aware that Rule 1.260 provides that a motion for substitution of party needs to be made within 90 days of that suggestion of death upon the record. And if not, then the action shall be dismissed as to the deceased party. That 90-day window closed on March 1st, 2021. And so, of course, at the time of serving our motion, we were about 2 or 3 weeks post the closing of that 90-day window, and no motion had been filed. Clearly, I think a cursory review of the record of Your Honor's docket would indicate that within those 90 days, no motion for substitution of party had been filed. And by the way, this isn't a suggestion or recommendation. I think the rule makes it clear that
I think the rule is pretty hard and fast.
Explicitly required, right? And so, and just so we're clear, because I think this may come up depending on how Your Honor rules on this motion. This case has been sort of stagnant for the past 6 months since the plaintiff passed away in November of last year. So not much by way of discovery, no expert mediation or arbitration, no motion practice, since there technically hasn't been a party sitting in the plaintiff's seat since November 18th of 2020. And believe it or not, we're still on a trial docket for next month, which I, of course, would argue is an impossibility at this point, and may need to be addressed if Your Honor isn't inclined to grant our motion at a minimum to dismiss this case without prejudice. But I guess that's an issue that we'll tackle if need be. But I figure opposing counsel will likely argue that they eventually did file their motion.
Let me ask you a question. I'm familiar with the case law about the deadline. However, I'm not recalling at the moment what the case law says about the dismissal, whether it's with prejudice or without prejudice. I seem to recall it's without prejudice, but I'm not 100% positive about that. So what's your understanding of the case law, or do you have anything you can cite to me?
Yes, Your Honor. So the case law, it sort of all falls in line with the appropriate remedy being a dismissal without prejudice, because of course courts are more inclined to rule on the merits of a case before they grant a with prejudice dismissal. And so, of course, at a minimum, we would argue in the alternative that the case be dismissed without prejudice, of course, if Your Honor is so inclined.
Okay. I just want to check.
Okay.
All right. Anything from Ms. Guerrero that you want to add?
No, Your Honor. I think Andre covered everything. Thank you.
All right. Ms. Stocks, response?
Yes, thank you, Your Honor. Simply put, it was a mistake not filing the motion for substitution. I thought it had been filed. It was drafted earlier this year, and in February I had a changeover in staff, and I thought that it had been filed. I thought all the parties were proceeding pending the substitution, that we were going to reschedule the mediation and non-binding arbitration that had been coordinated. So once I realized it had not in fact been filed, it was filed on March 26th of this year. And as Your Honor acknowledged, the 1.260 is a hard and fast rule, but the courts have held that while it's mandatory, the statute has been interpreted liberally to allow substitution of a party after 90 days of the suggestion of death upon a showing of excusable neglect, inadvertence, mistake, or fraud pursuant to Rule 1.540B1. Specifically, I rely on the second DCA case, Tucker versus Firestone Tire and Rubber Company. That's 552 Southern 2nd, 1178. That's a 1989 case out of the second DCA. It discusses the King case that defendants have cited in their motion to dismiss. But the Tucker court states that King even acknowledges that relief is appropriate under Florida Rule of Civil Procedure 1.540B1, where there has in fact been excusable neglect. And also a third DCA case, Pearl versus Kelly, that's 442 Southern 2nd, 1092. In the Pearl case, the court again suggests that the rule should be interpreted liberally. And that it even cites the Cantor case that's also cited in defendant's joint motion. And there it distinguishes that in that case, it was 2 years after the suggestion of death before the motion of substitution was granted. Also, the courts in this state have a longstanding tradition in favor of the disposition of an action on its merits, and that all doubt in favor should be resolved in favor of allowing a trial upon the merits. That's Jackson.
We also have a long-standing tradition of applying the rules and the statutes of the state of Florida. So, you know, kind of.
I understand, Your Honor. I acknowledge that the motion was filed about 25 days late. Again, it was
after they filed their motion.
Yes.
Or on the same day, actually, but their motion was filed first.
Yes.
Correct, Your Honor. Again, it was inadvertence. I thought it had already been filed. I was working with the personal representative. The estate's already been opened. Everything is in motion to be substituted so that we can get back on track. I would request that the court deny the motion so that we don't waste all of the resources that we've already used in getting the case in a posture for mediation and non-binding arbitration so we can move it forward. And again, based on the case law allowing a liberal construction of 1.260, we would request that the motion be denied.
All right, I disagree. I don't think that there's a liberal construction of this rule. I think it's a pretty hard and fast, bright line rule. The cases that you, or at least one case that you cite, deals with a situation where they could not get the PR appointed within the time period. And that perhaps is why they, back in that era, decided to make an exception. But that's not what we have here. And so the court is going to grant the motions and dismiss without prejudice.
Thank you, Your Honor.
So I'll need an order. You can combine all the motions in one order. After you've circulated it, forward it to my office email address in Word format.
Will do. Thank you, Your Honor.
All right, thank you, counsel. All right, next case is Parsons versus St. John's Insurance Company, 20 CA 4000. Who's here for the plaintiff?
I am, Your Honor, Gabriela Ibanez for the plaintiff.
All right, and who's here for our defendant?
Good morning, Your Honor. Mark Projecta for St. John's.
All right, this is a motion, plaintiff's motion to compel, and also plaintiff's motion for protective order.
We're just here to discuss the motion for protective order. We've already come to an agreement as to the motion to compel.
All right, that one's set for tomorrow, I think, right?
I think it's the affirmative defenses, the motion to strike affirmative defenses for tomorrow.
Oh, okay. All right, so go ahead. Defendant's motion, or no, I'm sorry, it's plaintiff's motion. Go ahead.
Yes, plaintiffs hired Leo Garcia, who is merely a consulting expert. Defendants have asked to depose them. We've explained to them that Mr. Garcia will not be our expert witness, but they still would like to proceed with his deposition.
All right, well, and let me just clarify. We don't have, in this case, I don't believe we have a case management order yet or a pretrial order, correct?
Correct.
So there's no deadlines in terms of listing expert witnesses. Okay, go ahead.
Correct. Yeah, so we don't believe his report, opinion, or testimony regarding the same is discoverable, and we do consider it work product, and defendants haven't shown exceptional circumstances as to their need to depose this consulting witness.
All right, counsel, response?
So, this is pretty simple. I don't have a problem with them not naming this engineer as an expert yet, and I understand the rules regarding not being able to depose an expert who's merely a consulting witness. However, I certainly do have the right to depose the engineer as a fact witness, and especially because this engineer was hired by the plaintiff pre-suit. He inspected the property. I should be able to ask him about his inspection. And essentially, this lawsuit was likely filed based upon this based upon this engineer's inspection. So I don't think there should be an issue with me deposing him merely as a fact witness at this time.
Any response, counsel?
Yeah, the fact that he said that we use this engineer to determine whether or not we would proceed with litigation are clients, the plaintiffs, used the engineer to decide whether or not they wanted to proceed with litigation shows that it was work product and it's not discoverable at this time since we haven't.
So I'm going to grant your motion for protective order.
Thank you.
Without prejudice, and deny their ability to depose him and get discovery from him at this time. It may change if you decide to name him as an expert. But at this point in time, then you don't even have any deadlines for doing that. So I don't even have a deadline that I could move up. So hopefully you guys are going to be set for case management soon, except I don't see an order for that. I'm going to have to email somebody about that. Just note to myself. Also, if you want to speed it up, if you want to do an agreed case management plan and send it to us, well, you don't need a case management conference. So up to you, but I will make sure that we get an order out.
Okay.
All right.
Sounds good, Your Honor.
So I'll need an order from you, counsel, after you've circulated it to my office email address in Word format, please.
Sounds good. Thank you, Your Honor.
All right. Thank you.
Thank you, Judge.
Give me a second, everybody, to catch up. All right, Baldwin versus Privilege Underwriters. This is 20 CA 3154. Who's here for the plaintiff?
Joe Jansen for the plaintiff, Your Honor.
All right, and who's here for defendant?
Ben Bernstein on behalf of the defendant, Your Honor.
All right, this is defendant's motion for protective order, so go ahead.
Yes, Your Honor. Good morning. So we're here on our motion for protective order regarding plaintiff's first request for production and notice of taking corporate representative deposition, Deuces Tecum. This dispute arises out of first party property claim for damages to the insured property. It's fairly straightforward. The request for production lists 38 requests, and the Deuces Tecum, the notice of taking corporate deposition, Deuces Tecum, the Deuces Tecum request lists those exact same 38 requests and also designates those requests as an area of inquiry for the corporate representative's deposition. The requests are, the information sought through the requests are generally overbroad, not relevant to the subject claim, not limited in time or scope, and seek information limited by the work product privilege and attorney-client privilege.
Okay, specifically, what are you objecting to?
Specifically, it seeks information from the insurer's claim file and information from the insurer's claim file and underwriting file, information regarding the defendant's claims handling practices and business practices, which are only relevant to a bad faith action, and coverage is still in dispute here. So we're just seeking an order, and we've attached various orders that were entered by this court, limiting the discovery and the testimony of a corporate representative in that respect, just to information that is not subject to the work product privilege or the attorney-client privilege, and information that, and limiting it to information only relevant to the subject claim.
All right, Mr. Jansen.
Well, Your Honor, I must say unfortunately, 23 years of practice, this is the first time I've ever received a motion for protective order on a request for production.
Really? Because I've got 500 of these cases, and believe me, I get this motion every single time.
I served a request for production on February 4th. To date, we have no response, and we don't have a single document or a privilege log to a request for production. I understand that the defendant may believe some responses are objectionable. The proper method would be to object to them. A motion for protective order is an extraordinary relief. And yet today we don't have.
My understanding is that we're dealing with not just request to produce, but also subpoena Deuces Tecum, correct?
There is a motion, it's not a subpoena, it's a notice of corporate rep depo, yes, and it's attached. We don't have any objections to that either. And both of these documents that we served are the same documents that we've been using for the past 7 years, and we've never had an issue where in corporate rep depositions where we went too far or anything else. The defendant provides the documents which they believe are relevant, they assert their objections, and then we move forward.
I understand. What you're saying is they haven't responded at all.
Nothing.
I got you. All right. So, Mr. Bernstein, that is actually inappropriate. You need to file a response pursuant to the rules. with regard to the request for production and produce what you think is relevant or think is not objectionable, and then obviously set forth an objection and the basis of that objection to the ones that you find objectionable. That is correct.
Yes, Your
so
Honor, and
why
we will
has
do
that been done?
The issue is we did reach out to opposing counsel various times requesting that they limit their discovery requests, and then they served the notice of taking corporate rep deposition, which includes the exact same requests, which is why we scheduled this motion to address both.
The request to produce was filed on February 4th, 2021, and here we are sitting in May. So you've had a long time to deal with this. All right, well, again, what I'm going to do is give you today is Wednesday, I'm going to give you to Friday at 5 o'clock to file a response to the request to produce. That means you can assert any objections that you think have a legal basis, and then we'll be back here on a motion to compel, but that's the proper way to do it. In terms of the subpoena ducis tecum, the only thing I can say, especially with you guys scheduled this for 15 minutes without me going through each and every one of these things, is to say that no, they don't have to produce their claims file. They do have to bring the claims file so that if they're asked questions that they need to refer to, they have that ability to do that. And again, without addressing each and every request in the subpoena ducis tecum, for example, some photographs are going to be work product, surprisingly enough. Some, notes from the adjuster, maybe work product. I mean, there's lots of things in there that's going to be work product. And without knowing exactly what we're talking about, I can't really rule on that. But so you may want to postpone your deposition till you get this straightened out or not. I don't know. But that's as much as I think I can help you today. So Mr. Bernstein, if you get me a order to that effect, after you've circulated it, send it to my office email address in a Word format. And I think that's as much as I can give you in terms of some guidelines today. And if you need me to go through each and every one of these, A, you're going to have to schedule a lot more time, or B, take it in front of the magistrate.
No, Your Honor, I appreciate your attention to this matter. We were just seeking a general order, just limiting discovery to information not protected by the work product privilege.
Well, I can't make that ruling. What I can say is there's going to be some information in that file that is work product. I can't tell you what it is at this point in time because I'd have to have an evidentiary hearing to do that, and a much longer hearing. But I can definitely say I'm sure that there's some information in there that's work product. I don't know what it is at this point. Okay. And you haven't filed a response, so we don't know what it is either. Okay. When you file your response, if you're asserting a privilege, you need to file a privilege log.
Understood, Your Honor.
That's part of the order. So 5 o'clock Friday, you've had plenty of time.
Thank you, Your Honor.
All right. Thank you, counsel.
Thank you, Your Honor.
Take care.
All right, I have 2 cases left. First case is Commercial Electric Systems versus Gates Butts Institutional Construction, 20 CA 2080. Who's here for the plaintiff? Anybody? Huh, that's interesting. Hold on. Oh, did they come off, Kathy? Did they settle?
I believe so, because I don't have that case.
Oh, okay, well, good. All right, then last case is the estate of Ziegler. This is 20 CP 932. Mr. Hayes, you're here representing the personal representative?
Correct, Your Honor.
All right, Ms. Yuri, who are you representing?
I'm representing the respondents, Gladys Macy and Diane Ziegler.
Okay, anybody else representing anybody else? Okay, you guys have 30 minutes for this hearing. And hold on, I'm just setting my timer. All right, so this is a motion to dismiss by Mr. Hayes. So go ahead.
Actually, Your Honor, it was filed by Attorney Yuri, and I represent the personal representative.
Sorry, I forgot. I got it switched out. Ms. Yuri, go ahead.
But as a preliminary matter, Your Honor,
okay, hold on.
this is set for 30 minutes, as you said, which we were fine with when this was initially scheduled because we think this can be dealt with in well under 30 minutes.
Mhm.
However, on Friday, Attorney Uri filed a witness list saying that she planned to call 2 witnesses to testify, an exhibit list with multiple exhibits, as well as multiple cases which she intends to argue. So I question how she's going to do all that in the 15 minutes allotted to her for this hearing time. So this is a preliminary
Yeah,
matter.
because you literally have 30 minutes. Each of you have 15 minutes, and I have a hearing that's supposed to start at 9:30. So we're not going to be going past your 30 minutes. And I sincerely doubt you can do it in 15. What do you want to do, Ms. Uri?
Well, we'll go through it as fast as we can, Your Honor.
I'm sorry, what?
We will proceed as quickly as possible, Your Honor.
Oh, you will be cut off at 15 minutes. Do you understand that?
Yes, Your Honor.
Okay. All right, go ahead.
Okay. This is a motion to dismiss based on lack of personal jurisdiction and the fact that it would offend notions of fair play and substantial justice. Rosalie Ziegler was a lifelong resident of the state of Indiana, except for a very short time when her daughter, the petitioner Carmen Keough, snatched her from Indiana against a court order of guardianship in Indiana, brought her down to Florida, got a voluntary guardianship over her in Florida, and she was here from December of 2018 until August of 2019, whereby she returned back to Indiana and remained there until her death. During that time, she obtained an Indiana ID, and also the death certificate reported the fact that she was a resident and legal domiciliary of the state of Indiana. On September 2nd, 2020, she executed a will in Indiana, revoking the will that is currently attempted to be probated in Florida, whereby she appointed Ashley Collier, the attorney, as the personal representative of her will. Ashley's here to testify that the will was valid and binding and that she had capacity. Rosalie was under a voluntary guardianship in Florida, never determined to be incapacitated in Florida, and possessed the full ability to revoke her 2019 will. Carmen Keough was fully aware of the will and fraudulently filed the 2019 will in Florida with full knowledge that there was a 2020 will filed. She's now attempting to probate that will in Florida with herself as personal representative. And Florida
Are there assets in Florida that need to be addressed?
No, Your Honor. All the decedent's property was located in the state of Indiana. Her homestead was in the state of Indiana. She had some bank accounts which have PODs, and I believe the only asset that would be in Florida would just be a guardianship account, but everything else is located in Indiana. So, this court lacks personal jurisdiction over the case. It's clearly stated on the death certificate.
I got it the first time you said it. All right. Mr. Hayes, anything you want to tell me? Is it by way of opening statement?
Well, first, Your Honor, if you look at the actual motion to dismiss, which has been filed and that was set for hearing today, we believe it's now moot. If you look at the request for relief, she's asking you to deny probate of the last will of Rosalie Ziegler and deny the petitioner's appointment as personal representative. That has already occurred. Letters of administration have been issued to my client, Carmen Keough, and the order entering the will to probate has already been entered. So this motion to dismiss is moot. I don't like to tell people how to practice, but at this point, this should really be a petition to vacate the order and letters or a petition to revoke probate. But a motion to dismiss is not procedurally correct. And we can address the substance of Attorney Uri's arguments if you want me to get into that. I'd be happy to do so. But as a preliminary matter, I just think this motion to dismiss is moot.
Ms. Uri?
Your Honor, The order admitting will and letters of administration were improperly entered into the court record.
Okay, but the point is it's not a motion to dismiss situation. It requires a different pleading.
But Your Honor, at the time we filed this, it was correct. The will was admitted and the probate was filed on March 30th. We promptly filed our motion on April 8th. This court was obligated under the law to not issue the order admitting will or letters of testamentary estate, but did so anyway on April 13th. So the motion was filed.
The problem is that there's a filing lag when people file stuff. So I'm sure that I did not see a motion to dismiss when I signed.
Well, it was filed on April 8th, Your Honor, and we CC'd
it was filed on April 12th, and I signed these orders on April 13th. So I strongly suspect that I did not see this motion to dismiss.
And there also was not a caveat filed, Your Honor. That would have been the appropriate measure if Attorney Yuri and her clients wanted to prevent you from entering, issuing the letters and entering the order. A caveat should have been filed, which it was not.
All right, here's the problem, Ms. Yuri. You haven't set this up right. So I'm going to continue this proceeding, whatever this proceeding is. I'm not going to rule on your substantive issues. You know, I haven't heard your opening statement, Mr. Hayes, so, you know, I'm not making a ruling, but there do seem to be some problems here, Mr. Hayes. But you are correct that this has not been set up procedurally correctly. These are complicated matters. They usually require people that do a lot of probate. So you may want to access that also. All right. So, and also if you're going to have, you know, more than basically opening statements and somebody identifying an affidavit, which I noticed that you did file, you're going to have to schedule more time. So for that, you'll probably have to call my office and get some hearing time.
Okay, Your Honor. In the meantime, could we freeze the estate assets so that...
You have not set it up properly, Ms. Yuri. You need to file the appropriate filings to do what you want to do. I can't, you know, this file's already been messed up because for whatever reason, I did not see this motion to dismiss when I signed the order. You know, I'm not going to mess it up further by entering orders that are not based on the correct procedures. So anyways, that's where we are. Govern yourself accordingly. All right, thank you. That concludes
Your Honor.
hearing.
Thank you, Your Honor.
I'm awaiting Michael St. Jacques, and I see some new faces that I'm not familiar with.
Okay, well, we'll sort that out. Who's here for Web Roofing?
Your Honor, Scott Pauser on behalf of Web Roofing.
All right, and how about for Brandon Jordan?
Good morning, Your Honor. Yasser Laclefi on behalf of Brandon Jordan.
All right, and Mr. Finch, you're here for?
Myself, Your Honor, I was contacted to be a potential witness if this is an evidentiary hearing.
Oh, okay. And Mr. Stewart, you're here representing the committee, correct?
Yes, ma'am, I am.
Okay.
Yes, ma'am, I am.
Who else?
I see Michael has shown up.
All right. Who's here? Okay. I think we just had somebody join. Who's that?
Good morning, Your Honor. Michael St. Jacques on behalf of the plaintiff.
All right. So it sounds like we're all here. All right, we're here. I set this on defendant's JR-5 emergency motion for appointment of a receiver. I've got an hour and a half this morning, and if we need more time, I have some this afternoon. If we don't, that's fine. But first, let me ask, is the plaintiff actually objecting to this?
Your Honor, we're objecting on grounds of jurisdiction based upon the appeal. Brandon Jordan has appealed Judge Hayes's order appointing the SLC, or I'm sorry, recommending and enforcing the SLC's recommendations on grounds that it's in the nature of a receiver, and that is on the face of the notice of appeal. So I provided the court with 2 cases.
Okay, but there's no stay that's been issued by this court or the appellate court.
Understood, Your Honor, but the issue of a receivership is on appeal currently in front of the Second District Court of Appeals.
Well, and given the fact that they've now asked for a receiver, I'm sure that they'd be happy to withdraw that appeal. So is that?
Your Honor,
you don't represent Brandon Webb, so why are you objecting on his basis?
It's not his basis. It's an issue of jurisdiction.
And Ms. LeCunnin, let's not pretend. Let's be straight.
Certainly.
Why is it that you guys are objecting to this receivership?
Your Honor, first things first. Again, we've not, since filing this lawsuit, objected to having any third party making decisions. To that end, the parties agreed to the Special Litigation Committee and further agreed to extend the scope of services that the Special Litigation Committee would provide.
Okay, but Ms. LeCunnin, you know that these parties cannot make decisions together. They can't even abide by the recommendations of the special committee. Why is it that you do not want to have a receiver? I want a legal basis here that makes sense, not one that is just a precept.
Your Honor, this isn't a precept. The issue of jurisdiction is jurisdiction. There's nothing I can do on grounds of jurisdiction.
But you don't represent the party that has that argument. So, okay.
Well,
I will conclude that you do not have a basis that actually makes sense. So let's move on. Is anybody else objecting to the appointment of this receiver?
And Your Honor, if I may, I just want this to be clear for the record. The grounds that we're objecting on is exactly what you just said. If Mr. Jordan wants to appoint a receiver, we need to clear up the jurisdictional issue. He needs to withdraw and dismiss his appeal of the order enforcing the Special Litigation Committee. That order is currently on appeal. If this court appoints a receiver, the court is necessarily amending an order that's on appeal. That order provides for a quote-unquote mini receivership. So that's the issue. We have an order on appeal. If a receiver is appointed, we're necessarily amending an order on appeal. So in our response, we said, look, you want this, that's fine. You just need to dismiss your appeal. You're not posting a bond anyways, so you haven't stayed the enforcement of Judge Hayes' order. So, Your Honor, we're not, and I want to be clear on the record, we're not disagreeing to the appointment of a receiver. We're simply trying to clear up the jurisdictional issue that is currently before this court. And that jurisdictional issue relates to an order that's on appeal that provides for a quote-unquote mini receivership. That's all.
I heard you the first time you said it. All right, so who else wants to say anything about this receivership? How about somebody representing Brandon?
Your Honor, Yasser Khalifa here. Regarding jurisdiction, obviously I would disagree with Ms. Lukanen's point. The order on appeal does not appoint a receiver. It's in the nature of receivership for the purposes of immediate appeal, but there's no such thing as a mini receivership. So I think the court is well within its authority to appoint a receiver at this time.
Well, let me ask you a question. I mean, just to her point, if I appoint a receiver, are you going to be dismissing your appeal?
There are parts of that order that I guess direct my client to deliver his own money, not the company's money. I believe that would be outside the receivership. So I don't think we can dismiss that portion, but to the parts that direct the transfer of company funds, that part we would certainly be amenable to dismissing.
Okay. Not that I have any jurisdiction over that, but just for everybody's informational purposes. Okay. So who else wants to be heard on this? Who's representing the entity again?
Scott Hauser, Your Honor, and we're in agreement with the motion to the appointment of the receiver. In light of everything, we think it's entirely appropriate for the court to do that.
All right, well, let me ask another question, which is, Usually when I appoint receivers, I appoint Mr. McHale. I'm not really sure that I can do that, given the fact that he was appointed as the committee. Am I correct? I mean, I don't have to appoint Mr. McHale. It's just, he's usually the one that whose name I can remember off the top of my head because he's done so many cases in front of me. I'm happy to appoint somebody else. Does anybody have a suggestion? Mr. Leclerc, you filed the motion, so who's your suggestion?
Yes, Your Honor. We've suggested Mr. James Howard, who is present before the court today. He's the managing director of B. Riley Advisory Services, which was formerly known as Glass Ratner. It's a national financial advisory firm. Mr. Howard has 35 years of experience with financial services.
It's not just financial services. We need somebody that's experienced in being receiver.
Right,
in the area of Florida.
Right, he's got experience as a receiver in Florida, and he's here today, Your Honor, and he can attest to specific situations where he was a receiver for companies in basically these exact scenarios.
Okay, well, I just wanted to find out who you're suggesting. Let me go to Mr. Pauser. Who are you suggesting?
Your Honor, we're in agreement with Mr. Howard being appointed. We've reviewed his CV and we've had the opportunity to read his experience as a receiver that it's set forth in the actual motion for appointment. And based on that, we see no reason why he doesn't have the requisite experience to serve as a receiver in this case.
All right, Mr. Conan?
Yes, Your Honor. Our position is the defendant in a derivative action should not have the ability to hand select a receiver, number one. Number two, he's also hand selected counsel for Webb Roofing, who, not surprisingly, is in agreement with the appointment of his chosen receiver. So without burdening the court, what we would recommend is that the court appoint someone.
I'm happy to do that. I'm waiting for you to tell me a name.
So I spoke with Mr. McHale. Mr. McHale said he would recommend, if he were asked, and he may be here today, he had a procedure yesterday, he would recommend Sonit Kapila, who is on the east coast of Florida. He has experience with construction matters like this, cases like this, and he would be his go-to. Soneet Kapila.
Do I have a CV from that person?
No, Your Honor, but we can provide one.
Because I think I have, if I'm correct, I think I have a CV from FVL Consultants. I don't know who that is. Do I have a CV, Mr. Leclerc, from your proposed expert?
Yes, Your Honor. That's attached to my motion, I believe, is Exhibit 2.
Your exhibits are ABC. If I'm looking at the correct motion, which was filed on May 4th. So Exhibit B, maybe?
I've got it listed as Exhibit 2.
Am I looking at the correct motion? It's a motion filed on May 4th.
It was refiled subsequently to attach the exhibits. Let me see the date on that. Yep, May 4th, corrected to add exhibits. Let me see. Okay, I see. Exhibit 1 has a number of lettered exhibits to it.
Oh.
After Exhibit 1, we've got Exhibit 2.
I got it.
Let me see what page that is of the PDF. That's page 147 of the PDF, Your Honor.
Okay. Got it. All right. Okay. All right. Well, first of all, it appears to me that what's required in terms of making a determination on the motion for receiver is a legal question. I don't need to actually have testimony with regard to that. And that's the legal question that was raised by Ms. Lukonen as to whether or not the court has jurisdiction to appoint a receiver. The court determines that it does have jurisdiction to appoint a receiver in this case. And as Ms. Lukonen stated, they don't have any objections to actually the appointment of a receiver. They have objections. Their concern was about the jurisdiction of the court. So the court's determining that it does have jurisdiction, and it is going to appoint a receiver based on the motions, as there doesn't appear to be any disagreement about that. Now the disagreement is about who to appoint. I would be more inclined to rely on the recommendation of Mr. McHale, because I think he's the only sort of unbiased party here. But I would be happy to. I have not reviewed the CV of Mr. Howard. I would be, and I have, Ms. Laconin has not filed the CV of the person that she's suggesting. So I'd be happy to review those. And also, if Mr. McHale doesn't look like he's here, I would have been happy to hear some testimony from him. But I can review the CVs if you want me to do that, and then make a ruling later this week, if that's what you'd like me to do.
Judge Joe Stewart.
Yep.
I spoke with Mr. McHale's office this morning. He did have a procedure yesterday. He was hopeful that he could attend, but he sounded awful, and so I wasn't going to allow him to attend today.
Yeah.
I've spoken with him in the past, and Sunit Kapila, it was his recommendation. I know Sunit from other large receiverships. He's over on the other coast, and his practice is pretty much is focused on receiverships and trusteeships.
And receivership and trusteeships of what types of organizations?
I've never been involved in one in which it was a construction case, but I'm sure he's had that experience. Mine have been fraud cases, investment type cases. Those are the couple of cases that I've seen him as a receiver.
Okay. Well, again, Ms. Laconin, what I need is his CV, and I'm looking at Mr. Howard's CV here. Let's see. I'm wondering whether or not he lists expert witnesses. I'm not seeing that he lists his engagements as an expert witness, but I'm not seeing that he lists any receiverships.
Your Honor, Mr. Howard is present before the court, I'm sure.
Right, but I'm not going to take, I mean, I will take testimony from everybody or nobody. So again, I have time this afternoon. If you can round people up to testify, I'm happy to hear testimony about it. But I can't tell from his CV whether or not he's actually served as a receiver, and if so, on what types of situations. So what's your choice? I can take testimony this afternoon, like from Mr. Howard and from Ms. Laconin's proposed person, and from Mr. McHale if he's up to it, but he doesn't have to.
Mr. McHale will not be able to attend this afternoon, Judge.
Okay, that's fine. So what would you like me to do, Mr. Lakifi?
Your Honor, if I may just add, for the benefit of the court, we did list specific instances for specific cases where Mr. Howard acted as a receiver in our motion.
Okay.
Where he acted as a receiver for companies that are in the situation that Web Roofing is in, if that would assist the court in making the determination.
Okay, I'm looking at your corrected, verified motion filed on the 4th. And let's see.
It starts on page 8 of the motion, Your Honor. Paragraph 16.
Got it. Okay, so it looks to me as though he has been a receiver in one case that of a similar nature to the one we have in front of us, which is the Landfall Strategies Company that specialized in providing post-hurricane cleanup for local and state municipalities with an ownership dispute, blah, blah, blah. Because here's the problem with the receiver. They're going to have to run the company. So they have to have some experience in this area. But my question to you, Mr. Lakhlifi, is would you be able to come back this afternoon so I could take some testimony? And Ms. Laconin, do you think Mr. Kapila would be able to give us a half hour or so to discuss his background?
Your Honor, I have for purposes of keeping this process as clean as possible, I have not spoken to Mr. Capilla. I'd be more than happy to submit his information to Your Honor for Your Honor's review. I can reach out to him to see if he...
Hold on. I get a better idea. Mr. Stewart, can you reach out to him?
Be my pleasure, Judge.
Okay, let's have Mr. Stewart call him and see if we can get him in front of the court this afternoon. As I said, I've got you guys down for 1:30 this afternoon because I wasn't sure. Sometimes these receivership hearings take quite a long time. So I wanted to make sure I give you as much time as I had available. So maybe we could come back at 1:30 and you can provide me with whatever you have. And if it's not,
Your Honor?
Yeah.
I have them down at 2:30.
Really? I have them down at 1:30. Oh, you're right. It's a 2:30. I'm looking at a different case. So it's a 2:30. Sorry. Thank you, Kathy. So at 2:30, let's come back and see. And by that time, we'll have also read the CVs more carefully. And Ms. Lukonen, if you can get it, or Mr. Stewart, if you can get a CV before that hearing, you can have it emailed over to my office and I'll look at it also.
Yes, ma'am. Judge, I have an engagement this afternoon. I'd like to be excused from the afternoon session. I'm happy to try and set something up with Mr. Capilla.
Okay, that's
but
fine.
I won't be able to attend this afternoon.
All right, and then would you just then let the attorneys know, Mr. Leclefe, Ms. Lukonen, and Mr. Pauser, what the status is on whether or not Mr. Capilla is going to be able to appear?
Yes, ma'am.
Okay, so they'll be able to report to the court.
Yes, ma'am.
All right.
Your Honor, before you leave down speaking, you're indicating you're going to take testimony from relating to whoever may be appointed as a receiver. That's not my function in this. Mr. Jordan's office was going to elicit my testimony for different purposes, and I just like for counsel to say what that is, so you can excuse me or tell me I need to go up because I don't.
Is that Mr. Leclefe?
Yeah.
Yes, Your Honor.
Yeah. What was Mr. Finch here for?
Just as a fact witness for the need for a receiver, but he's no longer necessary at this point.
Okay. So I am granting the motion for receivership. The question here is, who am I appointing? So that's what we have left to do this afternoon.
Your Honor.
Yep.
I apologize.
That's okay.
I have no intentions of interrupting, but just a couple of, from my perspective, housekeeping issues. We do have this appeal that's pending. However, no stay has been issued, so it continues to be, from our perspective, an order that should be enforced. So we'd be curious this afternoon to know how Your Honor's intentions, what your intentions are with that particular order and enforcing that particular order.
Well, I've already issued an order enforcing the prior order. So other than me showing up at somebody's office, or with a bailiff, I mean, there's not much I can do other than say, orders of the court are supposed to be complied with. And I'm assuming that a reputable receiver would see that and also comply with the orders of the court and would take that into consideration in whatever they have to do going forward.
Okay, and that's my point. Within that order is this process that was provided for by Mr. McKell. So, the receiver's effectively going to be overlooking part of that order in order to do their job. That's our perspective in looking at the order.
Now, they may need to do some different things because Mr. McHale didn't have as much power as, in fact, he had no power. He just could make recommendations as the receiver will. But yeah, I'm assuming that any reputable receiver is not going to ignore orders of a court.
And then secondarily, and probably more importantly from our perspective, is having a proper bond put in place at the appointment of a receiver. There's a per curiam opinion from the 2nd District Court of Appeals that makes it clear that an applicant for the appointment of a receiver is required to post a bond sufficient an amount to protect the opposing party. So here, much like the bond that we requested to stay the order enforcing the Special Litigation Committee's recommendations, we would further ask this court to consider this afternoon what the receiver bond is going to look like, if it's on the same order as Mr. McKell testified to at the last hearing, but what the amount of that bond should be when the receiver is appointed.
All right, and I'll need to have some be prepared to tell me what you think. Don't just tell me whatever you want, Judge. I want to know what you think also. And also, you need to understand that I may order the bond be paid by the company and not the individuals. So this is a benefit to the company because these folks cannot get along and cannot clearly abide by orders of the court. So I may be considering that too, but I'm going to need it. I'm going to need a number. So, all right. I'll see everybody at 2:30.
Your Honor, before you go,
Yep.
You referenced this order. Fromming and Finch did some of the work for web and roofing, and we've been ordered to do things in that order, never made a party to the action, and the orders, including the one you just referenced that you entered, have never been served on Fromming and Finch. We're directed to do things and send things to places, and we've never made a party to any of these actions and aren't copied on any orders. And it causes a lot of consternation. So,
Okay, well, I can't address that today. The receiver is going to have to address that.
okay, thank you, Your Honor.
All right. All right, so I'm going to see everybody at 2:30.
Thank you, Your Honor.
Thank
Have a nice
you.
day, everyone.
All right, Kathy, we have an 11 o'clock, so I'll log back in at 11 o'clock.
Okay,
All right, thank you.
thank you.